I'm here to talk about mediation, and the idea of mediation is that the mediator assists the parties towards a settlement which they themselves reach. It's not like a court case or an arbitration where somebody imposes a decision on you. In a mediation, the parties make their own decision, but the mediator helps them make that decision. And that's what I've always believed in for mediation. But I have to say that I've done several hundred mediations, I suppose, over about 15 years. I do more arbitrations these days, but I am asked to do commercial mediations from time to time. And I guess that people don't ask for me unless they want to perhaps in some way draw on my experience as a judge or as an arbitrator, over 20 years as a judge and 15 years or so as an arbitrator. And that means that if they want me to, I will give some reality testing in private in the caucus sessions to a party to perhaps indicate that they might be being a bit ambitious in their claims and to induce a bit of reality. But I do not give legal advice. That's the job of the lawyers, because I always require for mediations that the parties have proper legal representation. And normally people are pretty, commercial people usually have enough sense to have competent lawyers. And whereas in the court you don't always have competent lawyers before you, but most commercial parties do. So one is greatly assisted by the lawyers. Because of the sort of mediations I do tend to get to require people to give me some idea of what it's all about. Some forms of mediation, the mediator doesn't know anything about it, and the subject matter doesn't really want to. He or she sort of just tries to get the people to agree, but I wouldn't be happy with that. I like to know what it's all about, and so I require people to give me a sort of position statement, and also a statement as to what they expect out of the mediation, what their hope is, and they can tell me that privately if they don't want to come out to the open, because anything a party says to the mediator privately cannot be disclosed unless the person making the statement agrees. I do tend in mediations to emphasise one or two things. First, most important, is confidentiality. Confidentiality is very important in mediation, because you can say things that you don't want to come out in public, which would emerge if you went to court, and also, of course, without prejudice. In other words, you can't use what was said in a mediation in a subsequent court case. If your efforts to mediate or settle don't achieve anything, you can't use anything that was said at the mediation, and that's always made completely clear, because everybody who does a mediation has to sign a mediation agreement and a confidentiality agreement, and they have to sign up to those most important things. That's the first important thing. The second important thing is flexibility. When you go to court or an arbitration, the judge or the arbitrator can only do what you've asked that person to do. If you want damages, you can award damages. If you don't want damages, you want an injunction or something, then they can award that. But at a mediation you can think laterally and think of some other solution which appeals to somebody. I remember once a mediation about copyright and with an artist, is a singer really, a pop singer, and the claim was for damages or something like that, but for, I can't remember the detail now, but for reproducing a performance without permission. Anyhow, the upshot was that the artist who was not terribly financially well off, received a contract, and he was pleased. But that could not have happened if he'd gone to court. All they'd gone to court was he might have got damages or he might not. So the flexibility, you can think outside the litigation square, as it were. And the third thing is that, of course, it saves costs. I'm pretty sure that in every jurisdiction like Singapore or New Zealand, where I come from, in England, certainly the costs of litigation are just, blowing out of the water. Voltaire once said that I lost a lot of money twice in my life, once when I lost a court case and once when I won one. Because there's, in addition to the money point of view, there's always the stress and worry about court cases. Am I going to win? And it's typically court cases take a long time to get off the ground, and you've got a huge period of worry, so that mediation can eliminate that. And if you get a good settlement, usually that's one which both sides are a little unhappy about, and lawyers will tell you that's usually a good settlement. And in a few weeks' time you'll say, well, the best bit of work I did was to settle that case at the mediation. And that's often therapeutic for people to not have this particular worry of litigation, which does get people down. And as to international arbitration, well, it's mediation rather, sorry, it's the same as with domestic mediation. You get two parties together, and I have actually done one in Singapore a couple of years ago. A party in New Zealand and had a huge insurance problem arising somewhere in some rather remote part of the world, and the insurers were in England, and because it made sense to come to Singapore because both parties had to travel, and in the end they saw the insurance problems were huge, but in the end there was an agreement. So it is possible. It doesn't matter how complicated it is, because, well, I guess after many years on the bench I'm used to sorting out complications, and usually the complications are not as huge as you might think. There's usually 2 or 3 matters in any form of litigation which are the most important, and which you should try and get people away from the peripheral stuff and get them onto the really important things to face up to.